Right, so welcome everyone to JFF workshop for March. I'm really excited about today's paper because having read it and then really looking at the work of our discussants, I'm really looking forward to their engagement with Arudra, your paper. I haven't researched death penalty. I obviously am familiar with the arbitrariness ideas that you're looking at. So that's kind of going to be the angle of my comments and some of my questions that I have, but I will hand over to our discussants first. So the format of the session is that Aparna and Mrinal, who I believe should not need any introduction in the audience here, will be giving their comments. Arudra, on your paper, I'll then hand back to you for a very brief reply before I open up to the rest of the attendees for their comments and their questions. So I'll go in alphabetical order. Aparna, we'll start with you. And then Mrinal, you can just come in as soon as Aparna is done. Yeah, thanks, Aparna.
Thanks, Swati. Thank you for having me again. I really enjoyed the first time I was a commentator here, discussant here. Looking forward to this one as well, particularly because this is such a fascinating paper. Thank you so much for this, Arudra. You know that I've done some work on the death penalty, and I've looked at questions of arbitrariness in the court's jurisprudence on the death penalty, but your paper really made me think about my own arguments and, to think about it systematically. And I realized as I was reading your paper that, I've been using arbitrariness to cover a whole range of issues, and it bears sort of teasing out those elements to be able to better construct an argument about the death penalty, not just in terms of arbitrariness, but also, as you know, I'm working on proportionality of the death penalty under the sort of the structured proportionality test, and just sort of engaging with your paper made me sort of tease out some of the elements of my own argument in a way that I don't think I would have without having read your paper. So thank you really for that. My questions these are more in the nature of broad questions rather than comments about the paper. And the first one that I had was about your audience. I know you say that you're talking about the death penalty somewhat in the abstract. You're not making it contextual. It's sort of acontextual. But I wonder if you can actually make an argument about the death penalty in that acontextual, atextual kind of a way, because you do have an understanding of the justification for the death penalty that you're responding to as being retribution, as you yourself recognize. That is not the framework within which the Indian death penalty discussion takes place. So already you are contextualizing. And I wonder whether, what your audience is, and since this is a chapter in a book that itself has, expressed stated aims, I wonder if you need to be a little bit more conscious of audience and therefore of context. Two questions that arise from that. One is, you tell us what your theory of retribution is not, right? You tell us that it is not the retribution as revenge, which is the understanding in sort of mainstream judicial discourse on death, on sentencing in India, which India discards. But you don't sort of build a positive case, sort of the positive notion of what you mean by retribution. And so I was left somewhat sort of struggling with seeing, how does your argument really fit in within the framework of retribution without knowing what it is that you are understanding retribution as. So that's one thing. The second thing is, and this goes back to the question of audience and contextualizing. If the argument is to speak to an Indian audience, then as you notice, retribution is not the framework. In the Indian death penalty context, in Bachchan Singh, of course, the court says that death penalty is to be given in the rarest of rare circumstances where the person is incapable of reform. And reform as the purpose of punishment is something that the court has repeated in various contexts in the context of criminal justice in India, and you know that. But in the context of the death penalty, this focus on reform means that the purpose of the death penalty is either incapacitation, right? This person is not capable of reform, therefore needs to be incapacitated, or some kind of a general deterrence. The specific focus on incapacitation means that the death penalty is very individual. The determination of death penalty is very individualized. And if it is individualized, then some of the concerns that you raise in your paper may have to be thought of a little bit differently if the entire point of a death penalty determination is to individualize the sentence, right? So, for example, you know, when you're thinking about arbitrariness as consistency, right? You set up the example of two equally situated persons, right, who are otherwise in all material respects are equally situated, but are given two different sentences. And you see this as a sentencing mismatch, right? Under the Indian framework, this would not be a mismatch, right? This would not be a problem. This would be a requirement, because you have to individualize that decision. And that's why judges, for example, will say arbitrariness doesn't make sense because each case is unique. We have to look at the circumstances of each individual. So, you know, I was thinking, you know, theoretically of a case where there are two co-conspirators. I'm just assuming that factually all of this is proved, that there are two co-conspirators who've committed an offense. They tried for it. They're charged the same. There's the same witnesses. They have the same lawyer. They're both convicted of it, and they're both up for sentencing. And the question is whether they should be given the death penalty or not. The Indian system would require an individualized sentencing at that point, and a sentencing mismatch would not be a problem. It would be, like I said, it would be a requirement. It would be in keeping with the theory. So I was just saying that, you know, you built up this assumption that retribution is sort of the highest standard for you to beat. And if you can show that retribution doesn't, that your arbitrariness claims can defeat a retribution rationale, then you know, everything else is a lesser threshold. I'm not sure that's the case. That you would still have to engage with these kind of questions of individualized decision making. The second point that I wanted to make is about your standard failures, right? So again, I really liked the demarcation that you make in the different types of failures at the different stages, and then the standard failures and the discretionary failures. And I wonder if you want to add to your standard failures two examples that come from the Indian, there are two other types of standard failures that I could think of from the Indian example. One is that there might be different standards and judges choose which to apply, right? So we know that in Bachchan Singh, the court gives a particular standard. By Machi Singh, that standard has changed. In the 2000s, the court is sort of formulating its own standards. So there might be different standards, and I didn't see that really in the framing that you have. There's it could be a case of that the standards are broad and vague, but I think this is a distinct kind of a problem, that there are different standards and judges don't know which standard to apply. The other one, and I think that's the more substantive point, is that you could have a standard failure which is not arbitrary but still discriminatory. And I know at some point you talk in the beginning about how you're focusing on arbitrariness, not discrimination, but discrimination will come in at a different point. But I do think there's a standard failure also which is not arbitrary but discriminatory. And I'm thinking of indirect discrimination here. Of course, Tarunabh is here, he's the expert on indirect discrimination, but I'm thinking of, you know, I mean, in the US context, the whole discussion around punishment for cocaine and crack cocaine, right? Of crack cocaine, of powdered cocaine, which is something that is generally consumed in, say, Ivy League dorm rooms by privileged white, youngsters is something that is that attracts much lesser punishment than crack cocaine, which is generally something which is cheaper, easily available, and is consumed mostly. Is more likely to be consumed in black neighborhoods. So it's a that indirect discrimination kind of a claim. And I have in previous work looked at, and I'll send you that paper, looked at some of the gendered assumptions around neutral standards with respect to the death penalty, particularly when courts have looked at, say, what is the standard that will apply to the death penalty? What are the kinds of offenses that one would think would attract the rarest of rare standard, meet the rarest of rare standard? The courts said that these are offenses relating to property, so disputes relating to property that lead to a capital offense, disputes relating to political power, and disputes that happen in the public sphere, and have regularly discounted disputes in the domestic sphere or disputes relating to honor killings, so on and so forth, from the purview of what is an offense that is heinous enough to attract the death penalty. And I say this not to say that all of these offenses in the honor killings or disputes in the domestic sphere should necessarily attract the death penalty, but just to say that these sort of facially neutral rules themselves encode some kinds of biases, and it might make sense to sort of expand on that in your standard failures, right? So those are the sort of arbitrary, but not arbitrary, but discriminatory. It is not to say that these are not relevant considerations or that they're not applied consistently, but they're still discriminatory. So that was the larger point I wanted to make. I know I'm really running out of time, so just I had a couple of reading recommendations. I see one, of course, I didn't see a citation to the Law Commission of India report, so I was going to say the Law Commission of India report, but obviously you know that already. But in the last part where you're talking about procedural safeguards, one of my favorite quotes is from on the death penalty is from this judgment of the US Supreme Court called Callens versus Collins, and it is if I remember correctly, but I have it open here somewhere, this is by Justice Blackmun, and he says, from this day forward, I no longer shall tinker with the machinery of death. For more than 20 years, I have endeavored, indeed, I have struggled along with the majority of this court to develop procedural and substantive rules that would lend more than the mere appearance of fairness to the death penalty endeavor, rather than continue to coddle the court's delusion that the desired level of fairness has been achieved and the need for regulation eviscerated. I feel morally and intellectually obligated to simply to concede that the death penalty experiment has failed. It is virtually self-evident to me now that no combination of procedural rules or substantive regulations ever can save the death penalty from its inherent constitutional deficiencies. The basic question, does the system accurately and consistently determine which defendants deserve to die, cannot be answered in the affirmative. It is not simply that this court has allowed vague aggravating circumstances to be employed, relevant mitigating evidence to be discarded, and vital judicial review to be blocked. The problem is that the inevitability of factual, legal, and moral error gives us a system that we know must wrongly kill some defendants, a system that fails to deliver the fair, consistent, and reliable sentences of death required by this constitution. And I thought that just captures very beautifully so much of what you're trying to say. And I could just imagine that as a sort of a epigram to your chapter. Okay, I'll stop there.
Thanks, Swati, and the rest of the JFF team for inviting me to comment on Arudra's paper. Like Arudra mentioned, I think we've had discussions in the past on this issue, and I should have guessed that because this is part of the book project, and I think that makes it more interesting because all of my comments are going to be on things that I think other parts of the project, the part of the project that I am part of, where we're looking at procedures, etc., might tie up with what you're doing, Arudra. So I think we should keep this conversation forward so that we connect our chapters. So again, thank you. This is not a lens from which I have in the past looked at questions of sentencing. And so therefore it was very useful for me to look at the manner in which you had approached the issue. And so thanks for that. So I have a few comments and a couple of questions. I think Aparna already mentioned the first one that I was going to refer to, that is the assumption of retribution as the philosophical basis for capital sentencing. You of course cite the writings of van der Haag and use that as a basis for the assumption on retribution. But if you were to look at the Indian courts, except where they have referred to society's cry for justice, or like you mentioned, collective conscience as the justification for imposing of the death penalty, you do have cases where the Supreme Court has said that retribution does not fall within the Indian constitutional order at all. So any sentence that is imposed using the retributive framework would be unconstitutional. So therefore, I think that's something to think of and engage with. And also in more recent times, like you mentioned, the context in which your course also at IIT-Delhi began in the context of the 2012 gang rape homicide, and the sections which are introduced thereafter, 376 capital A and the various other alphabetical iterations that you have thereafter, where death penalty is provided in the context of sexual offences and sexual offences related homicides, articulate deterrence as the theory that they're following. So that might be something to look at to see how that fits into your argument, and whether the argument would still hold, of how you modify the argument to that extent. The second one comment I had was in the context of debates on institutional imperfection, where you say that there's not too much intellectual work in India in this context, and that's right. There's not too much intellectual work in that context. But if you look at again, this is my chapter in the volume on pre-sentence hearing, and that's a very interesting thing, because pre-sentence hearings were introduced into the 1973 CRPC, was not there in the 1898 CRPC, with the specific purpose of bringing standards and fair process in sentencing. But over the last 50 years, it's really not happened. And so you see the Supreme Court basically sidestepping it by giving some justifications as to why it's not absolutely necessary. It is necessary, but it's happened here, and things like that, factually using that. So the failure of this process is indeed debated, but probably outside the death penalty and abolitionist framework. So that may be useful to consider as to the failure of this process, and how the institutional failure has been debated by courts outside the process. The job may be easy for you, because I am probably going to do that, so you can tag on to that and give the philosophical basis of how you would react to something. I found your definition of sentencing mismatch very interesting. You say that when two people who are similarly situated in terms of desert receive different sentences, there will be a sentencing mismatch, if I understood you correctly. So in my work, I refer to definitions of unwarranted disparity in sentencing. And in sentencing theory, unwarranted disparity is defined and is, as a situation where the sentencer does not adhere to the theory of punishment that they have to follow. Or if they follow the theory of punishment but do not use factors that are relevant from the point of view of that theory, then the sentence is considered to be disparate and is considered to be unwarranted. So I am curious to know whether your sentencing mismatch definition requires that there be equality of outcome, but not equality of purpose. Is it about equality of purpose or equality of outcome? Andrew Ashworth discusses this in quite a bit of detail about the importance of equality of purpose, but not necessarily the equality of outcome. So how does that fit into your sentencing mismatch definition? Because if you say equality of outcome, that means all similarly situated offenders should receive exactly the same sentence, which again ends up making it arbitrary. So that's one. Again, the loci of arbitrariness that you construct is very useful. And here again, I have a couple of comments. First, something that I already spoke of in terms of the pre-sentence hearing, and I'll get back to that again. But in terms of pre-trial arbitrariness, although again, it definitely exists in the Indian context, I would urge you to consider other instances which will be more useful to make your argument. For instance, with Supreme Court judgments like Lalita Kumari, it is difficult for the police, not impossible of course, to decide what crimes to investigate. Charging is also a process in which there is judicial oversight. So I would be more concerned with questions such as the lack of a proper discovery procedure, the supplying or non-supplying of relevant documents and evidence to the defense, and the like, where the judge and the police have wide discretion not to supply documents, to hold back evidence, not to provide discovery-like procedures. Similarly, questions of access to counsel during interrogation, which has come up both in the death penalty context, but more in the PMLA and economic crimes type context. A question on which you have differing rulings of the Supreme Court, and where the judge can decide one way or the other, I think is again an example of this arbitrariness in the pre-trial process. So these elements, I think, may strengthen your argument rather than the ones that you have currently used in the paper. Again, second is again something about the pre-trial, pre-sentence hearing process, which I think would fit into your trial arbitrariness loci. Where in order to ensure that sentence does not get invalidated due to the process not being followed properly, the Supreme Court has gone to the extent recently of saying that if the procedure is followed in spirit, it meets the requirements of the pre-sentence hearing as mandated by the CRPC. This to me is a clear indication of arbitrariness on which basis one could propose a moratorium or argue for abolition, saying the safeguards that you brought in the 1973 CRPC outside of the Bachchan, prior to Bachchan Singh, of course, has completely failed. So it is, like I said, it's not possible to do anything about it. So why don't you have a moratorium in that context? You also speak about prosecutorial discretion in charging. I agree with you that in the Indian context, there's immense power that the police especially have to file a charge sheet or not to file a charge sheet. And they may determine whether a person is charged for a capital offense or not. However, the one thing that I would ask you to consider is whether there is really that much discretion in homicide-related offense, homicide especially, because the framework
our worst fears realized. Mrinal, we lost you there just as you said the framework.
Yeah, I realized I got disconnected right at that point. Yeah, so like I said, the framework within which the homicide jurisprudence works in India and Indian Supreme Court cases in the context of homicide say that you have to follow Section 300 and Section 299. So there might not be that much of freedom autonomy in the hands of the police to not charge or not file a charge sheet rather under Section 302 and go straight to 304. If they do that, then of course there are high-profile cases where there's been an attempt to do something like this, and that will attract attention both of the courts as well as, like you said, media and other civil society actors. So I guess all these situations amount to leveling up, as you argue. So that everybody is now being charged for a capital offense and then you try and bring it down. And so this arbitrariness and leveling up seems to be tailored into the system in the context of the definitions of culpable homicide amounting to murder and not amounting to murder in the IPC itself. I have a question on this on standard failures and discretionary failures. If you do have a situation of a standard failure, especially when there are standards that an adjudicator is required to adhere to in sentencing, could one argue, as is done in sentencing guideline systems across the world, including India in the context of death sentencing, that abuse of discretion is a ground for appeal or possibly review in the context of a Supreme Court judgment in India. And hence arbitrariness may not arguably lead to wrongful outcomes. So how would you respond to something like that? And lastly, on the question of rectification, there's an argument with something that I refer to in my book on sentencing, which ties up with the dissent in Bachchan Singh by Justice Bhagwati and his judgment in the E.P. Royappa case, where he says that judicial discretion can also be judged. There's judicial review available for judicial discretion, and judicial discretion can itself be exercised arbitrarily. So a court is also state within Article 12. In response, H.M. Seervai basically does not agree with that and says that if we were to accept the Royappa arbitrariness definition, then the entire sentencing system in India is unconstitutional. So Seervai says because of the fact that we get to this absurd situation, we cannot accept what Bhagwati is saying in Royappa and subsequently in Bachchan Singh. So it might be useful to refer to this argument, both in Seervai's book as well as in Justice Bhagwati's these two opinions, to talk about that the part where you say that rectification might not be the ideal way to deal with this issue. Yeah, thanks. So those are my comments.
Thank you so much, Aparna and Mrinal. You gave us a lot of food for thought. So I've been making notes based on your comments because a lot of them connect with some of the questions I had. But before I get to my questions, and I have Tarun in the queue as well, Arudra, would you like to take like a short few minutes to just give your reflections on this? And I will request to take as less time as you want because we'd like to just maximize comments for you from the floor.
Thanks a lot, guys. This is very, very helpful. A lot of this is detail, which I'm just going to, just take on board. And I'm certainly going to, one of the failures of the paper right now, I think, is not framing this within a broader sentencing, theory of sentencing kind of framework. So I'm going to ping Mrinal and get lots of references and start reading that stuff. I thought maybe I'll just say one thing in the context, in the big picture framing context that Aparna mentioned. Who's the audience and why do you choose retributivism as a frame? I think actually in my mind, there are 3 or 4 audiences. There's the, there's the average IIT-Delhi undergrad student who might be coming to a class on criminal justice really without knowing much about the law, without having thought that much about criminal justice and justice, but who in my imagination, maybe is a kind of default retributivist. So it's not, not against the death penalty as a kind of default. And by the way, one of the things I do in the class, this is something I wanted to put on record, but since both of you were involved very centrally in the Law Commission report on the death penalty, when I started teaching this material in early 2013, there was a questionnaire on the death penalty, which you would circulate and ask for responses. And I gave that to my students, said, look, if you want to send this on, you fill it in, and if you want to send this to the Law Commission, I'll post it for you. And I did. And at the end of the course, I asked them to fill out the questionnaire again after having done this theoretical work and also some of the empirical work from your, and I've done that over the years. And it's quite interesting. I think people come in maybe in a default retributivist sort of mode and are pretty okay with the death penalty. And, they do change their minds in interesting ways towards the end of it. My sense is that in a way, both Indian legal academia as well as the Indian judiciary is in a bit of a bubble. And I think, doesn't want to talk about retribution because it seems like theoretically, unkosher. But in a way, if you think of public opinion overall, I imagine that, there's and certainly the discourse around the death penalty for rape or child rape, or, I think the core there is is retributivist in nature. And I wanted to write something that responds to that core without taking it. So I think, and this is maybe a part of a broader philosophical kind of thing, respond to the best arguments against whatever view that you have in mind. So I'm coming from that perspective, which also informs this more general analytical philosophy framework that I'm coming from. I don't say anything about, do I have a positive theory of retribution? I do think that there is the core, the core idea, punishment, well, it's a proportionality idea. People should be punished to the extent that they deserve, no more, no less. I think the Kantian formulation, this idea that, suppose the world is going to be destroyed tomorrow, are you going to let the worst of the worst criminals just free? Wouldn't there be some reason that's not a forward-looking, deterrence-based reason to see that they get their just deserts? I find that compelling. I think at least it's not a straightforward thing to dismiss. And when I started teaching the course, I think like you guys, I thought, that's a non-starter. But if you go into the details of the philosophical work, I think it's much harder to. I mean, there are many things you can say, and there's a big and rich debate. But that's why I thought so put it this way, I take retributivism seriously in a way that the Indian judiciary and legal academia doesn't. And it's kind of strange, you think that in a country where there's so much support for the death penalty, it's actually very hard to find academic work or, serious writing that actually supports the death penalty. Maybe Ujwal, what is the name of the prosecutor in Bombay? Ujwal, not, anyway.
Ujwal Nigam. Yeah.
Ujwal Nigam, thanks. He has a YouTube video which is, he's pro the death penalty, but there's actually nothing sustained. And I think you can't really argue against the death penalty without, again, taking the strongest view. And I think the US experience with discussions of arbitrariness in this whole Furman line, there's a rich literature there, and I'm keen to respond to that as well. I'll just say one last thing, which is in the connection with what you talked about. Well, what about incapacitation versus retributivism? I think both are equally individualized. And you just say, the purpose would be different. But in the case of incapacitation, you'd have this additional variable, what's the chance of, further misconduct. In the retributivist framework, that would not be an element. But there, if you're retributivist, you have to be individualized because you care fundamentally about proportionality, and that individualization would come from things like aggravating and mitigating circumstances. So maybe I should stop there because I'm conscious of going on and on and on. But thank you both. This is very helpful, and I am going to follow up with these comments.
Thanks, Arudra. So I'll hand over to Tarun.
Thanks very much, Swati and Arudra. This is a really interesting paper and very easy to read, which is one of the things we try to benchmark and showcase in the JFF. So thank you for conveying complicated ideas. Well, I know this is work in progress, so there are things that obviously need to be tidied up. So I'm going to pick up on some of the things that have been said and add a few others. The first on who you are citing. So I want to start by pointing out Farah Ahmed's fantastic piece on the Citizenship Amendment Act. I've posted a link here in the chat box, which to my mind is the best analytic unpacking of arbitrariness that I've seen anywhere. And I don't think that you can write a paper on arbitrariness now, and not just in the Indian context, but especially in the Indian context, because you ought to know this, without deeply engaging with this paper. As a sort of more general matter, I do think it's also problematic to so completely orient all our analytic toolbox from one single jurisdiction, the United States, which is itself, quite obviously pathological, infamously inward-looking, and a jurisdiction where so much of the scholarly argumentation is strategically directed at ongoing litigation, because there's a revolving door between the academy and practice. So I would take that with a pinch of salt. And it's not a jurisdiction known for its analytic rigor and clarity. There is a lot else that's good about it, but not rigor. So I actually think that, and this adds to Mrinal's comment about looking up Searwise work. There is material elsewhere, and I think it's important to acknowledge that. And and as I said, Farah, I think, has done a better job than many of the people that you have cited. So you must really engage with it. So that's the sort of first point about who you are talking to and what literature you're engaging with. The couple of minor points, and then I'll just say a few things about arbitrariness. First is, I think, you use the language of implicit, explicit discrimination. I think just the language of direct and indirect discrimination outside the US is so settled now that I would just stick to that. Unless you are using explicit, implicit in a different sense, and you're trying consciously to say something else, I would just stick to the direct and indirect discrimination. And, maybe even cite the Nishita case that the Supreme Court recently decided with I think it's put all completely beyond doubt that indirect discrimination is part of Indian jurisprudence. So I would certainly do that. The third thing I want to, you spend a lot of time on the distinction between arbitrariness and discrimination, but inconsistently. So the first thing I want to say is that in the discrimination literature, the fact that not all discrimination is arbitrary and not everything arbitrary is discrimination is long established and is completely it's so central. So I've just put in some page references in my book, which distinguishes between descriptive and normative relevance, right? So if you think of, many examples, an employer not hiring a woman in her 20s because he's worried that she will take maternity leave, which will be more expensive, is using her gender as descriptively relevant, and rightly so. It's not arbitrary. Gender is normatively irrelevant. We don't want employers to take it into account, right? Or a publican not hiring a black bartender in a racist neighborhood is not acting arbitrarily, right? Because race is descriptively relevant to that context. It's normatively irrelevant, right? So this distinction between discrimination and arbitrariness has been long established in the literature. I also sort of will just, in my chapter on Article 14 in the handbook by Sujit Chaudhary, Madhav Khosla, and Pratap Bhanu Mehta, sort of talk about non-comparative arbitrariness and comparative classification wrongs as the two legs on Article 14, which might be also interesting to look at. But what I'm saying is you don't need to do a lot of heavy lifting to establish that point, because that point is sort of not debated. If you do want to think about it, one of the people who has actually made the contrary claim somewhat and is sort of against the tide in the literature is a book by Ben Idelson called Discrimination and Disrespect, which I think is the closest and very sophisticated argument that comes close to suggesting that what might be going on in discrimination is something akin to arbitrariness. Just know that it's very much it's not the mainstream opinion. I think Ben would struggle with the kinds of cases that I have just mentioned. So that's just by way of sort of clearing the ground on where the discrimination literature is. Now, the final sort of, I think the big question about this paper, the big contribution this paper can make is to help us think about what arbitrariness is with the lens of death penalty. And while the ambition and the promise of the paper is great, I think the execution sometimes fails to meet the standards it sets up. So there are lots of other things that are like arbitrariness that in the literature and in the case law are often used interchangeably. And at places in the paper, you do the analytically rigorous thing of trying to distinguish it or explain how they exactly relate. But at times you yourself fall in the trap of using them in a mutually interchangeable manner. So, I'm just throwing ideas. We've just talked about arbitrariness and discrimination, but also how does it relate to unfairness, wrongful outcomes, comparative wrongs, injustice, procedural irregularities, miscarriage of justice. There's so much else in the neighborhood. And, as you know, since your methodology is analytic, the foundational analytic method is to find related ideas and to distinguish or to define relationship. Is arbitrariness a subset of injustice or not, right? So if I go to a restaurant and choose arbitrarily from the menu, I just decide I'll have the third option, right? That does not seem to me to be unjust or arbitrary or wrongful. And so on pages 8 and 9, you use the idea of locus, whose point of view, who can claim, right? To think about arbitrariness. But again, in my example, nobody has a cause to complain, right? So I think bringing up locus muddles the waters, right? Is arbitrariness a wrong against person, or is it a fault in the decision, irrespective of whether if it affects people? Is that an additional wrong, independent of whether the decision is arbitrary? So some of these things, I think, will need to be tidied up. And then having tidied it up, once you have drawn all the Venn diagrams, where is the overlap? What is the family relationship? Is something a subset? Is something a classification? Is something completely different? Keeping a laser focus on that core of arbitrariness to explain whatever else may be wrong with death penalty, wrongful outcomes, etc. They add to its wrong, they compound the wrong. But arbitrariness, strictly speaking, is itself a wrong, or maybe not a wrong, right? But I think unless we identify that core, the moral vocabulary will remain confused. So I think you set up the challenge really neatly, and I know that it's a very difficult challenge to meet, but because you have come so close, I just think you can push ahead and meet it. Thank you very much.
Should I respond to individual questions, or just let people respond and then say anything at the end, right? I'm not supposed to respond.
May I add to the list, Arudra, and then is that okay? Yeah. So I think a lot of what I wanted to say is Tarun captured in his comments on arbitrariness. I too wanted to refer you to Farah's piece, just to give you some starting points and bearings on how you're going to look at arbitrariness. So I'm not going to go in any particular order with my comments, and I'm going to just proceed on the basis of just giving you my reactions to the paper rather than trying to figure out whether they fit in with the ambitions of your paper. So the first reaction I had was, I really was thinking whether you want to at some point step away from the depth and detail of your paper and really crystallize your research question. Because as I was going through your introduction, I sort of picked up 6 or 7 different points of emphasis that you want to put on the broad institutional questions. So your opening line is, in this chapter, you want to look at a line of reasoning about the death penalty. And then further down on page 2, it's then to look at what are the thresholds of institutional imperfection that you might be willing to absorb. And then there's also the idea of providing a taxonomy of arbitrariness arguments. And then further down, there was the idea that, so I'm looking at page 4, where you say you're going to argue that arguments do in fact provide a reason to either impose an indefinite moratorium, at the very least, if not abolish the death penalty. So I wanted to get a sense of just what is the distance you're trying to run with the institutional question and how far you wanted to get your conclusion to go, because I think that connects to what Tarun is saying about the execution part of the paper. If you crystallize your end game, then it will help you to figure out what kind of execution you need to do to get to that end game. So that's just one thing. The second thing is I was really curious about a comment you make on page 5, where you say the arguments discussed are general and concern the morality, but not the legality or constitutionality of the institutions involved in the death penalty. And I thought that was a really, I was very curious about that three-way distinction you're drawing between moral, legal, and constitutional, sort of on the assumption that these are watertight and separate categories, and there's no overlap or conversation between the three metrics as such. And I feel like, given the flavor of your paper, I think it is really looking at sort of the constitutional fallout of a lot of the conclusions and discussions that you're having. So it's a very small, it might be a very small comment, but it's sort of connected to what is the ambition of this, because in the last paragraph in section 1, you say you're going to be suggesting a jurisprudence of mitigation to deal with some of the arbitrariness problems that you identify. So there is sort of a legal, constitutional sort of outcome, doctrinal outcome to the paper. So all of this is connected to crystallizing the ambition of your paper, so you get what your execution burden is that you have to discharge. Okay, on arbitrariness, I had sort of 3 comments. One is, when I looked at your loci of arbitrariness, so this is where you set up your taxonomy of selection, trial, and judgment arbitrariness. The first is, they seem to be functionally different problems. So sometimes you're looking at things that are sort of definitions of arbitrariness, so inconsistent selection or inconsistent treatment. And sometimes you're looking at causes of arbitrariness. So for example, when you talk about judgment arbitrariness, it's not that the judge is doing something arbitrary, but it's the outcome that's arbitrary. So it just felt like the concept was operating on multiple planes. Sometimes it was defining arbitrariness, and sometimes it was causing arbitrariness, and sometimes it was doing something functionally different. So you may be okay with that, but I just wanted to kind of acknowledge that that's how I read your taxonomy. Then the second thing was, I think I just want to echo everything Aparna, Mrinal, and Tarun said about arbitrariness. So you've got lots of different concepts animating it: discrimination, consistency. I also kind of felt that some of the procedural stuff was really talking about fairness and procedural fairness. So just to kind of really figure out how you're going to deal with that definitional problem without it becoming too bulky a part of your paper. The biggest thing I had was coming at this from an administrative law kind of lens. The 3 kinds of arbitrariness that you set up, selection, trial, and judgment, to me, they're just categorically different and will have very different normative pulls when it comes to what do we do about the death penalty. So if I'm looking at selection, arbitrariness, and who gets prosecuted for what and what charges laid, to me, that's very different from a judge sitting there and having to apply vague criteria on sentencing. They're just 2 very different kinds of problems, and they have very different calls on what do we do about the death penalty. So yeah, so those are sort of my bigger substantive points. 2 small points, and then I'll end. One is Aparna and Mrinal were asking you to think about your audience. And I think in your response to them, you mentioned that you can envisage 3 to 4 different audiences, and one of them is students. My sense is that I think it would be important, again, going to the what is your ambition for the paper and what's your execution threshold, to really pin down which audience you're going to be speaking to and primarily transacting with, because I think that will help to just figure out like what is your paper pointing at. So I kind of like a TV in the room, who's it pointing at? So who's your paper going to be pointing at? Who's primarily going to be watching it, and who's kind of going to be listening to the TV in the background? I think it'll be quite important to do that. The last thing, and it's a really, really small point, at the moment your sections are numbered by numbers. I wonder whether you want to deploy the use of headings and title headings for your sections to give some signposting. And just for me as a writing technique, just having those subject headings is a really useful way of mind mapping my argument and really anchoring myself in it and sticking close to it. So yeah, so those are my comments, and none of this detracts from what is an incredible amount of work and depth that you've managed to capture in your paper in just 22 pages. I think, yeah, that's quite a feat. So I don't have anyone else on my list. So Arudra, happy for you to take some time to respond to anything you'd like to respond to.
Hey, thanks, guys. So, this again goes back to the audience question. It's nice to hear. It's nice to talk to this audience because in my head, I mean, students is one thing, but I guess so far the paper is written talking to, let's say, an audience of analytic philosophers concerned with the death penalty in this particular, American tradition where arbitrariness comes up a lot. And in my head, I'm sort of putting that in conversation with abolitionist arguments in the Indian context, which is, I think, for many years used the language of arbitrariness and capriciousness, possibly quite independently from that US trajectory. I have to look up. I don't have a sense. Aparna, you would have a better sense about the extent to which the early death penalty litigation in India refers to the Furman line of cases or not. But certainly, the lethal lottery, capricious news, Aparna's own paper, some of Yug Mohit Chaudhary's, a lot of the conversation and the moral outrage that this body of writing responds to, is couched in the language of arbitrariness and discrimination. And part of the this response more specifically to Swati, what you said about these different loci or loci being, categorically quite different. In a way, that's part of what I want to say. I think it's a big tent that in the abolitionist literature in India, and I think also in the US actually, classifies this all as instances of arbitrariness. But I think in fact, they are quite different. So it's part of the project of just to separate those things out. One thing I've left out, which is something Aparna pointed out earlier, is the arbitrariness and discrimination at the legislative stage, and that's off stage from what I'm talking about. And there's in the background. But let me say one more thing. So so for instance, in the UK, I've not heard this language used elsewhere, but you and Tarun would be able to correct me on this. The idea of a postcode lottery, that's certainly a phrase that I've heard used in the UK, and maybe not in the case of criminal justice, but economic inequality. So this, and both you and Tarun have talked about fairness. Fairness is another term like arbitrariness, which I think has to be unpacked in a whole range of different ways. So that's one point. I think I'm definitely, so this draft of the paper has been written really responding to a lot of the philosophical literature that comes out of the US, and the analytical philosophical literature, primarily this literature on the death penalty. Tarun, the literature I've been looking at, the scholarly literature, is actually not the legal literature so much as the philosophical literature, where I think that issue of it being written strategically, for abolitionist conclusions, I don't think that applies to this this range of literature. And I think one of the virtues of it is that, like I said, it takes seriously the retentionist perspective, and it takes people like Bant and Haag seriously attempts to respond to that. I'm 100%, because that's been the narrow focus with which I've written this draft of the paper. The particular definitions and the discussions in literature on discrimination, I just didn't have time to even engage with that literature. It's certainly part of my plans. I'm grateful. So like in the case of sentencing, as well as the case of discrimination, I think it's different bodies of scholars working on similar kinds of issues come up with their own taxonomies and definitions. From my point of view, not much rests on which I choose. I mean, as long as one can taxonomize things in a clear kind of way, that's not too out of tune with established bodies of literature. I'm very happy to replace the terms that I use or relate them to existing literature. So this is a function of current ignorance, but certainly the next draft won't see that. I'm trying to think what else. I guess this only comes up in a footnote, but part of the background conversation, which again, in a way would be weird, I think, for an Indian audience, is conversations about equality and in political philosophy in this kind of Anglo-American philosophical world. And so this question about the leveling up argument, the leveling down argument, is inequality a problem in itself, or is it a proxy for itself, or for something else like need, for instance. So one popular kind of picture that people like Joseph Raz have and Harry Frankfurt is that inequality by itself is not of moral concern. What matters is sufficiency. One person is very poor and one person is very rich. The fact that there's a distance, again, this is a claim that's made. It's not the distance that's the issue, but it's the fact that the very poor person is poor. That's the distinction between a comparative and a non-comparative point of view. So in fact, the piece by Thomas Cannon, the book by Thomas Cannon, something I've been thinking about, and he looks at this stuff in a glancing kind of way. But I guess this goes to, and it's helpful while talking about this, the focus in a way is on these two arguments. People who think that there is a problem with arbitrariness arguments from abolition, people like Van den Haag, and people who think that there is a problem with this call to overgeneralization. In fact, when I was talking to Anup, he said, look, it'd be nice to talk about that issue of is death special, and you see this all the time in any abolitionist debate, in any debate that actually takes seriously the the retentionist point of view. These things come up, and so in a way maybe it's a conversation with myself. If one takes these things seriously, what can one say that sort of absorbs the point of view of this these responses, and nevertheless works out some kind of possibly quite weak abolitionist conclusion. And I think it is a weak conclusion that's an offer. But maybe I'll stop for a moment, and I know Aparna has a hand up, or turn the chair back to you.
Go ahead, Aparna.
Thanks. Quickly, just to respond to the question Arudra asked, and then a couple of points to make. Concerns around arbitrariness have been there for a long time, predate Bachchan Singh, in fact. So in the 1973 CRPC, when that's being debated, the entire shift from death being the norm to death becoming the exception is itself being driven by concerns about arbitrariness. Jagmohan really deals with the question of arbitrariness happening around the same time. The 2-year moratorium on the death penalty that predates Bachchan Singh is largely being driven by the post-Maneka, post-Royappa sort of framing of reasonableness under Article 21, which includes arbitrariness. As in Bachchan Singh, the court is very centrally looking at the question. They say, as a substantive matter, as a matter of desirability, there's nothing we can say about the death penalty, and so therefore presumption of constitutionality will apply, and the death penalty is constitutional. But we have to take seriously this question of arbitrariness. And interestingly, linking to a point that Mrinal was making, in Bachchan Singh, they say that because now we have this pre-sentence hearing framework, that is a safeguard against arbitrariness, and so therefore that's another reason to say that this is not going to be arbitrary. So I don't know the development of law on this, but if, as Mrinal is saying, the courts have now reduced that threshold of what the pre-sentence hearing is going to, be like, then that directly contradicts what Bachchan Singh sets up as one of the reasons why the system is not arbitrary. So that's just sort of on the arbitrariness question. In response to something I said, you said that what you're trying to do with setting up retribution as the sort of the theory of sentence that you're placing your argument within, is that you want to give the best argument to the other side and then say why that doesn't work. And I would just push back a little bit on that again and say that, the audience question is important because it's because of your retributive framework that you're able to give the kind of examples, the thought experiments that you set up of this perfect parity between these two, characters A and character B, and then how do you figure out whether they've been dealt with arbitrarily or not. But like I said, that if your audience happens to be, and very often my audience happens to be, at least in my head, my audience happens to be sort of a legislator or a judicial decision maker in India, at least that's in my head. I know that for them, their argument will be, but I am not convinced because there is never perfect parity. So you are setting up a thought experiment that doesn't exist. And therefore, this question of consistency that you are so worked up about is not an issue that I really need to deal with. I need to focus on, and again, like I said, the incapacitation and the reform, the individualized reform requirement in Bachchan Singh places, I think, to a greater degree, the requirement own thing, just as a thought. Yeah?
Thanks, Aparna. So unless we have any other questions from the floor, Arudra, would you like to have a final response, or you're good to go? I know you must be overwhelmed.
No, this is great. This is very helpful. I don't know if I'm fascinated by, well, let me say two things. And again, this is an interesting audience to talk to. I hadn't thought about this going in, but in a way, I'm glad that the paper, as it stands, actually doesn't really talk about, jurisprudence. Jurisprudence of any particular jurisdiction. But even in the US, I've mentioned these cases because that's one tradition where, in fact, statistical thinking about the collection of statistical data on death penalty and death penalty administration was quite sophisticated. One thing that made me think about it, and I've never actually had a conversation with Anup about this, is that it's really only after this Project 39A, NLUD project, this kind of systematic and large-scale empirical data collection has happened. There's a certain kind of argument that one can make now that maybe wasn't possible, let's say 20 years, and think of that frontline article on the death issue of the death penalty was probably like 2005 or something, it was 15 years ago. Again, where lots of arbitrariness claims are made. So that's one reason why I've sort of made that reference to the US line of cases. So I'm kind of keen, I think, to abstract away from the particularities of jurisprudence. I think I should certainly gesture towards it and make known that these connections exist. But I think more and more, I'm not trying to address this, and this goes to Swati's point about the constitutionality, legality, morality thing. I'm not actually concerned to address it to, and again, maybe this is, maybe Gail, I need to sort of bump off the Zoom, since this has been for a volume on the death penalty addressed to precisely these audiences that I now say I have no interest in addressing. But yeah, I think there's a broader audience, even though it's an audience that is likely never to read the paper, that I think can actually be persuaded from first principles and not tied so specifically to either the text of a particular constitution or the fact that precedent has evolved in that jurisdiction in a particular kind of way. So I think I am keen to maintain that aspect, but maybe again I should say, in part of this stage setting and figuring out what the main aim is, say more about that upfront. Who are the interlocutors? And in a way, I think because in the Indian context these things haven't really come up, they're not urgent questions. I'm having to kind of recreate the interlocutors for the audience that will read the paper. Right? Who cares about who in India has heard about Ernest van den Haag? Beyond the authors of the Law Commission report, but these are the kinds of things where, again, I think, I just dismissed, and I think it's a mistake. I think the one that point when you read it is actually quite interesting, requires some thought to get around. But I think, I think for me, the journey has been actually in teaching the death penalty material. I thought it was so easy to sort of just dismiss it from a theoretical kind of point of view. And over the years, I've lost some of that confidence. I think I am grappling. And in the retributivist thing, I mean, I know if forget about the death penalty, if like Yati Narsinghan and Saraswati got like a fine of 5 rupees for making this, these hate speeches and that, I would think that's unjust. I would want him to be punished more because I think the gravity of his, of what he's done is, it's quite terrible. So I think that the idea that we perhaps have, kind of anti-casteral kind of vision that retributivism is problematic because it leads to a sort of escalation of punishment. I think that's mistaken. I think in many cases, first of all, perhaps we want escalation of punishment. And secondly, in fact, and historically, I think retributivism, theoretically at least, has come from a space of actually protecting the innocent. If you have this deterrence kind of perspective, you can go punish whoever you want as long as it will reduce the incidence of crime. But retributivism is so clearly tied to issues of proportionality, which I think, it can go either way. And maybe I'll stop there.
Thanks, Arudra. I think you have a couple of comments from Tarun and Tulsi in your chat, but Tarun also has his hand up.
Thanks, Swati. So just to elaborate on the comment I had in the chat, I think, Arudra, that, one of the things I thought was the strength of your paper was that you weren't focusing on within the doctrinal confines of the Indian jurisprudence. And I think, as constitutional and legal scholars, we often end up focusing too much on courts and assume that they are the only relevant constitutional actors. Clearly, the public discourse is much larger than the judicial discourse. So, I think that you should use Aparna's challenge as a way to frame your paper and make it into a virtue. And, there are lots of reasons, some of which you have given in your response to Aparna, some which you haven't, but you can frame that. So you can talk about the public protests demanding death penalty for various crimes. You can, I'm sure, legislative debates on every new death penalty crime that has been created over the last decade will be an extremely rich mining resource for talking about how retribution may not be officially accepted in the jurisprudence of the courts. It's very much an argument in the public domain, perhaps even a dominant argument. I don't know. You don't need to do that task, right? Of explaining its relative importance. We're just saying, look, it's an important argument. And if we need to move towards an abolitionist frame from the legislature, whatever, it needs to be dealt with. It needs to be tackled head on. So I would not be shy about it. I would actually put it up front, but you have to justify why you are talking about something that. So I think the way I would read Aparna's challenge is you don't want to be seen as beating strawmen, and it's important to show that you're not beating strawmen. And second thing, I would just inspired by Tulsi's comment, and hopefully she will also feel free to spell it out more. But there is a paper by Les Green on the duty to support imperfect institutions. I believe the paper is called The Duty to Govern, but anyway, you'll find it easily, right? So there's a strong strand in liberal jurisprudence that, human institutions will be imperfect. And their imperfection is a reason to improve them, not to get rid of them. And of course, that might be subject to a baseline level of moral soundness, which I think that penalty clearly fails to meet. But, and I'm not saying you necessarily need to engage with that argument in this paper. I think, you know, a good paper sort of brackets as many digressions as possible and keeps a laser eye focused on the main issue. It might be worth a footnote to say that, look, I know there is this argument, and I will take it to whatever, you know, a one-line dismissal, leave it for another day or something, maybe relevant. But yeah, I wouldn't make this paper about incapacitation.
Thanks, Tarun. So Tulsi, I'll turn to you next.
Hi, it's nice to see everyone. I don't think I and Arudra have met. I do not have much more than what I've put out in the chat box, but I think I'm generally very disinclined towards any arguments that seem to inflate arbitrariness and discrimination than what they actually are required to be, because so I think there's a general trend to count a lot of things as arbitrary and discrimination, which they are actually not and shouldn't be understood. And I believe that discrimination as a wrong should be limited to very, very specific kinds of instances, and that is the way we should see it. And it seems like, I mean, the paper, of course, is very interesting, and I really enjoyed reading it, because I think you try to connect something that is very exciting to speak about, the morality or the legality of the death penalty with something like discrimination, and that connection I think is fantastic. And I have not read many papers which have envisioned that kind of connection. But I still think that sort of inflating problems of criminal justice, generally speaking, to something like discrimination is problematic. And I think various problems that you point out, such as the different treatment when it comes to trial, the different treatment when it comes to judgment, are problems with how the criminal justice system is structured, and how a lot of institutions operate, which is very imperfect and which has serious problems. Apart from the problems of justice, has problems of implementation, has problems of inefficiency, and so on and so forth. And I think it might be a mistake to just conceive that as a problem of arbitrariness or as a problem of discrimination. Maybe that objection needs to have a better treatment, and I